In that letter, I also explained to Miss Ashwell that it was not necessary, not, excuse me, it was not necessary for her to run the gauntlet of the police by arriving at a hearing in Croydon. The proper thing to do would be to return to the UK and answer to the warrant in good time, so that on her release she could attend and take part in her claim. Of course, if she were detained, that would present a difficulty, but it would be difficult to refuse a request for an adjournment in those circumstances. Referring to Judge Fowle's usage of the phrase, it was not necessary for her to run the gauntlet of the police by arriving at a hearing in Croydon, this language is minimising, inflammatory, and portrays me, the victim of sustained and retaliatory abuse, as the aggressor or a criminal. The metaphor of running the gauntlet is highly prejudicial. It frames routine compliance with civil proceedings as a dangerous or illicit act, which is wholly inappropriate given my circumstances as a claimant reporting serious misconduct, harassment, and criminal acts by the respondent and their associates. Judge Fowle's further assertion that the proper thing to do would be to return to the UK in answer to the warrant is procedurally inappropriate. The Tribunal's function is to adjudicate employment claims, including workplace sex discrimination, bullying, and constructive dismissal. Under the Employment Rights Act 1996, the Equality Act 2010, and associated regulations, it is not the Tribunal's role to advise a claimant on compliance with external police matters, nor to influence unrelated criminal investigations. Doing so risks prejudicing the claimant and conflating civil claims with unrelated criminal proceedings, a principle reinforced in R on the application of Edwards v. Environment Agency 2006 EWHC 1698 admin, which confirmed tribunals are strictly limited to their statutory remit. I had already explained this to Judge Fowle in a previous request for his recusal, which was ignored. The use of running the gauntlet also minimises... Oh, this keeps happening. The use of running the gauntlet also minimises the seriousness of my claims and demonstrates apparent bias, implicitly framing me as an aggressor rather than the victim of retaliatory actions. In reality, the respondent, including its directors and associates such as Chris Robshaw, Camilla Kerslake, and my rapist, orchestrated measures intended to intimidate and silence me, including threats of arrest upon my return to the UK. These criminal cases were fabricated and are now in the process of collapse, highlighting that the respondent's intent was purely retaliatory. It is also notable that the respondent attended the hearing remotely by video, while I was denied remote access to my own hearing. This contravenes Rule 47.2 of the Employment Tribunal Rules of Procedure 2013, which requires the tribunals to consider legitimate explanations for non-attendance. Denying my participation while accommodating the respondent constitutes a clear procedural irregularity and demonstrates partiality. Previous claimants have been granted remote participation in similar circumstances, and my request for remote access was consistent with standard practice. Further, previous requests I made for safeguarding and investigatory measures were not actioned, which may evidence procedural unfairness under Rule 3 of the Employment Tribunal Rules of Procedure 2013, which obliges tribunals to act impartially, fairly, and in accordance with the overriding objective. Judge Fowle's language and direction cannot therefore be viewed as neutral. It prejudices the tribunal against me, undermines my right to a fair hearing under Article 6 of the European Convention on Human Rights, and exceeds the tribunal's lawful jurisdiction by addressing matters outside its remit.